I get to have with me Joe Wolfson, and Joe and I have known each other for several years. Before I jump into it, Joe, do you want to introduce yourself?
Sure. As you've heard from Darshan, my name is Joe Wolfson. I am an attorney with the law firm of Stevens and Lee. I focus in unfair competition, antitrust work, both on the litigation side and the corporate side. And as Darshan knows, I represent a lot of medical device companies, pharmaceutical companies, and private equity companies that focus in that space.
My first question for you is how does that add a dimension as compared to directly working with the pharmaceutical companies or medical device companies? Is there a different dimension to it?
Sure. When we're doing work with private equity firms and companies, they're looking to make an investment. So we'll work with them and do due diligence with them when they're looking at an investment. We're certainly not looking at the numbers and the business model, but there will be, especially in the medical device area, pharmaceutical area, legal questions that arise that we can add some value, such as, is the IP protected? Are there FDA issues that we should analyze? What does their marketing look like vis-a-vis their competition, so that they know if they're going to be stepping into any legal issues if they make an investment? And then finally, after they make an investment, we then often become outside general counsel to the medical device companies. And since we have an understanding of broadly of the industry, of what they're trying to achieve with the investment and with the company itself, we hopefully can add some value as their legal outside general counsel to the medical device company.
So do you end up being general counsel to the PE company or to the individual companies themselves?
Both. The way it works is that we'll work with the private equity company on the investment. So as I mentioned, we'll help with the legal due diligence, as well as help them with the purchase agreement, whether they're purchasing the entire company, purchasing an interest, just some shares. And then after that, we represent the company, and the private equity firm, which is also a client of ours, is one of the shareholders of the company. And the companies will waive a conflict, and we'll do it according to the book, but then we're representing the company and protecting its interests, which naturally, as we're representing the company, we're also helping the shareholders, because with any company, the goal is to maximize value for shareholders.
What kind of marketing pieces have you found yourself looking at?
Oh, it could be anything, Darshan, from comparative advertising. Our company, we have this medical device, competitors have that medical device, ours does XY, theirs does AB. And then just general marketing when it comes to an FDA licensed product, as you know better than anybody, and frankly, I will reach out to you quite often for this help.
There's another whole element to this, which is the FTC and states. And I find myself reaching out to you in those scenarios. Could you talk a little bit more about that?
Sure. And this is where it's important to have a multidisciplinary view when you're looking at medical device products in particular that are licensed by the FDA. Because just because the FDA says you can do something doesn't necessarily mean it's appropriate in the marketing space. Because you can say things that the FDA may say or think are okay, but they're not looking at it what it means in the marketplace. And that's where the FTC, Federal Trade Commission, the FTC comes in, state attorneys generals who look at unfair and misleading marketing that could affect consumers.
Talk to me a little bit about what is the FTC asking about? What are things that you've seen, and you and I have discussed this several times, but that you've seen, you know what? This might work from an FDA perspective, but here are the FTC issues that you guys should be considering. And if you can, the same answer, if you want to address it differently, how is that different from what the state AGs are looking at?
It depends on which state AG, of course, but they generally have the same view. The Federal Trade Commission is out there to ensure consumers are not misled. So what they would be concerned about is if let's focus on a medical device product or a pharmaceutical product, it would be misleading to consumers if the company is advertising in a way that may lead them to conclude the device or product has efficacy, medical efficacy that it otherwise really doesn't have or is not proven. And consumers could be injured by that. And that's why the FTC and state attorneys generals are concerned, because they want to avoid harm to consumers.
So I'm going to pull in what's going on right now. As everyone knows, this is happening in April of 2025, and there is chaos in the market right now because the Trump administration is changing and has a very different perspective on just what should be focused on. I guess part of what I'm trying to understand is some might argue that isn't this an issue of too many agencies looking at the same issue of either confusing consumers or problematic information going out to consumers? Is this something that can be put together, whether it's the FTC, the state AGs, the FDA, all looking at just advertising from different lenses?
They certainly overlap.
Right.
And I don't think that anyone is going to argue that there is not duplication. I mean, I could talk about various pieces of litigation that are brought by the FTC, and the state attorneys generals are also in that. However, if the state attorney general, for example, is bringing an action against a company, the beneficiaries of that are the individuals or the state citizens where the AG exists. So the FTC might obtain relief on a federal level, but the state will obtain relief on behalf of the injury to the state itself. So there is an overlap when they're doing enforcement, but the relief they seek goes to different buckets or pockets.
Do you think when you advise these companies, you are advising them at a state level? Or do you think that when they make the changes, anyways, they'll end up being federal changes anyways, but from a labeling perspective, a marketing perspective?
Yeah, what we generally advise our clients, and there are some outlier states which are far more aggressive than others, but in general, even with those aggressive states, if you comply with the federal regulations on the FTC, the FDA, and you market the right way, you will protect yourself both on the federal level and the state level.
What are the big trends you're seeing around litigation related to marketing non-compliantly?
Well, I think it's what it's always been. There's two different groups, two different buckets there. One is competitor litigation, where, and I'm involved in one of those right now, where a competitor advertises its product can either be used in a certain way or can obtain reimbursement a certain way. And there's a federal act, I should say, called the Lanham Act. And the idea behind the Lanham Act is that it's a federal statute. It's ostensibly a trademark statute, but it really extends far beyond just trademarks. It's any advertising that would tend to create a likelihood of confusion by the ordinary consumer. So if there's going to be advertising that would lead a consumer to reasonably believe the product does something or can be used in a certain way, or creates confusion about the product, or even which company it is owns the product. Another bucket of litigation is consumer litigation, where consumers say, you misled us with your product and we were harmed. And those buckets have been around for a long time, and they will always be around, in my view.
We see these ads on TV all the time. Have you been hurt by XYZ device, XYZ drug, which is often these mass torts that people are trying to create. So
that's a different bucket than what we're talking about.
Okay, talk to me further about that.
Yeah, what they're looking at is where a pharmaceutical product, a weed killer, a talcum powder, I mean, any product at all, where there are a group of people that believe they've been hurt. It's personal injury, product liability cases. Those aren't advertising in itself. Those advertising injuries. What you're seeing are advertisements for clients who have experienced personal injury. So that's a little different.
Any big parting words you think that we haven't quite covered here?
Yeah, if it's a marketing course, for example,
yeah.
I always would ask people to make sure they understand the difference between factual advertising and puffery. That is where a lot of companies fall into a trap, because the clear distinction, which is easy to describe but easy to identify in practice. In some ways, it's like the old Justice Potter line about pornography in one of the Supreme Court cases. I know it when I see it. Puffery are those statements that are mere opinion. In my opinion, this is the greatest product since sliced bread. If you make a factual statement that my product is better than my competitor's product because I have 2/3 better results, well, then you better be able to demonstrate you have the science in the 2/3 result. And the way I like people to think about, and I say this to clients, is if your statement is such that you could put the words at the beginning of it, in my opinion, and it doesn't change the meaning in any way whatsoever, that's puffery. The greatest product ever. But 2/3 better results, well, even if it's your opinion, you better be able to back it up. A factual statement can be actionable. And therefore, when I have clients that give me advertising to look at, if they're a little concerned, I always will look at it to see whether the words "in my opinion" change the meaning.
Again, for those people these are students who are listening to this, how can they reach you if they have questions?
Easily available. Go to our firm's website. It's stevenslee.com. My name's Joseph Wolfson, and my email contact information is on the website. And happy to answer any further questions that anyone may have.
Thank you again for coming on, Joe.
No, thank you, Darshan. It's always a pleasure working with you and speaking with you.
Call, click,